Now, for a follow-up, last night we reported the Quincy man convicted of killing his estranged wife wants a new trial. Tim Bliefnick's lawyers arguing he was denied a fair trial. Questions rose over if the jury should have heard testimony about Rebecca Bliefnick's state of mind before the murder. And the prosecution mentioned details in closing arguments that was not presented during the trial. Now, the Illinois Appellate Court is left with a decision on whether to grant or deny a new trial. Hayden Donaldson breaks down key moments from the hearing.
Bliefnick's new lawyers presented 3 arguments to an appellate court presided by 4th Circuit Judge Robert Steigman, as well as 2 other judges from the Illinois Appellate Court in the 4th District. The argument from Bliefnick's lawyers was broken down into 3 categories. The first argument by Assistant Appellate Defender James Waller was that the court admitted evidence that was irrelevant or not otherwise admissible under the forfeiture by wrongdoing doctrine. The state says the evidence presented was not allowed under the doctrine, stating the court can still use the witness's statements or evidence even if it wouldn't be allowed normally, citing another titled State versus Floyd.
We know that this is irrelevant to prove anything but propensity to commit a crime, and thus it's not proper evidence to admit under the forfeiture by wrongdoing principle. We also know from Floyd that a single instance of this is reversible error if properly preserved, as it was in this case. The
state responded by saying the testimony contained enough facts to be relevant.
It just doesn't seem to make any sense that a non-constitutional could not be harmless. Whether the evidence was actually overwhelming or the error was harmless in Floyd, it doesn't seem to be really presented there, but it is presented here. And so that's why I think this court should start the analysis of whether any error would have been harmless.
The second argument had to do with Josh Jones's closing arguments, where Jones told the jury of Bliefnick's internet searches about the case went beyond what was published and did not prove what had or had not been released.
We're looking at a case with no fingerprint analysis, no conclusive DNA analysis, circumstantial evidence, no doubt, substantial amount, but any evidence of motive is completely specious without this improperly admitted evidence.
The state said the internet searches were alarming and his searches warranted the relevance of being released.
He's not just preparing, or he's not just, investigating the investigation and the internet. He's researching how to open windows and doors. And so, I mean, the idea is that this is evidence that is admissible for things like opportunity and motive.
The third and final argument from the defense stated Judge Robert Adrian should not have presided over the case with his ongoing case with the Judicial Board, where he was later removed from the bench. Prosecutor Josh Jones testified against Adrian in the review case and says the case needed a new judge.
We want this case tried before a judge who's not indebted, showing overwhelming deference to the prosecutor, and we want this case tried without all of that irrelevant evidence.
The state's response was that in the case of Adrian, no rules were broken.
It just doesn't seem like, even if this was somehow reviewable or could possibly be error, it doesn't anywhere meet the standard of actual prejudice under the standards for substitution of judge. And of course, there was no actual motion made for substitution of judge, which been assigned to a different judge, but that didn't happen here. And the constitutional due process standard hasn't even been close to being met.
In their closing remarks, Judge Steigman asked the biggest question: what explanation could the defense come up with for how Bliefnick behaved and what he said? Waller responded saying it was not up to them.
Your Honor, it's not our burden to demonstrate theories of innocence here at this point.
I know it's not your burden, counsel, but I'm asking you anyway.
The appellate court will make a decision, but that decision is not known when it will be made. I'm Hayden Donaldson reporting.
Thank you, Hayden. Tim Bliefnick received 3 life sentences last year in April. This after being convicted on 2 counts of first-degree murder and 1 count of home invasion. Don't miss a video. Subscribe to our YouTube channel today for more Central Illinois news.